On April 3rd, 2025, there was another court hearing for ADOR's lawsuit requesting legal confirmation that their exclusive contract with NewJeans remains valid. So we're going to talk about this. But what I was looking for was whether NewJeans side and their lawyers, the legal law firm, Sejong, would have enough evidence this time to back up their argument. Because remember, last time, when the court made a decision with the injunction case in favor of ADOR and against NewJeans, NJZ PR accounts, which is allegedly managed by the parents of NewJeans members, made this statement saying, "It is important to note that an injunction is a provisional measure. A separate main lawsuit regarding the validity of the exclusive contract termination is currently underway, with the court hearing scheduled for April 3rd. Unlike injunction proceedings, the main lawsuit allows us to freely utilize civil procedure tools to collect necessary evidence. We anticipate this will greatly reinforce our claims." So I was like, okay, what kinds of necessary evidence would they come up with? And it turns out, well, we're going to figure it out, okay? So I'm going to read this article for you titled, "ADOR, You Can't Terminate the Contract Just Because MINHEEJIN is Gone. NewJeans, Trust is Broken. Judge Raises Questions." Okay? So here we go. Written by journalist Yoon Hae-young from Sports Today. At the first court hearing between ADOR and NewJeans, ADOR pushed back against the group's claim that former CEO Min Hee-jin was ousted, while expressing hopes for a settlement. NewJeans' side, however, stated that a settlement is not currently possible. On April 3rd, the Civil Division 41 of the Seoul Central District Court held the first hearing for ADOR's lawsuit requesting legal confirmation that their exclusive contract with NewJeans remains valid. The NewJeans members did not attend the hearing. A lot of people wonder, NewJeans members, will they attend this hearing in person just like the injunction case? But they did not. So some people were questioning whether they regarded this as a less important case. Or some people thought that, okay, it makes sense that they're not present because maybe they've realized that the public opinions are really against them now. But it turns out some fans, NewJeans fans, were there outside the court because we've seen some photos taken by some journalists. All right, but let's go back to the article. Previously, in November, 2024, the NewJeans members declared the contract void, citing a breakdown of trust due to ADOR's failure to meet its obligations. In December, ADOR filed a lawsuit seeking confirmation that their exclusive contract is still valid. So that's the summary. And some more. ADOR also filed for an injunction to prevent NewJeans from pursuing independent activities and signing advertising deals. Last month, the court sided with ADOR, effectively blocking NewJeans from engaging in solo promotions. The group filed an appeal on March 21st. So here we go. During the hearing, the judge recapped the situation by saying the defendants demanded corrections on 8 issues, and when those weren't resolved by November 29th, 2024, they declared contract termination. The plaintiffs responded on November 28th, but before the reply could even be reviewed, the defendants, meaning NewJeans, held a press conference and announced contract termination. The burden of proof lies with the defendants, but instead of proving their case, they unilaterally declared termination and refused to cooperate. Hence, this lawsuit for confirmation. And yes, if you remember, ADOR, NewJeans demanded, made 8 kinds of different demands, right? But ADOR sent their letters or replies to NewJeans worth 26 pages long on November 28th. But then they decided to hold a press conference in the evening anyways. despite this document that they have received. And interestingly, NewJeans' side revealed these documents through 일간스포츠, which has been a media agency that has written various articles on their behalf, on NewJeans' behalf. And at the time, a lot of legal experts said that the fact that they held a press conference declaring that their contracts will be terminated in a few hours, after receiving this document and even before reviewing this document would act against them. So they were saying, why did they decide to do that? Because it will be super unfavorable for them legally. And that's what exactly the court or the judge pointed out in the very beginning while recapping the situation. All right, the judge continued. The arguments are mostly a repeat of what was presented in the injunction hearing. As for the new claims, they weren't part of the original 14-day correction period, so they don't meet the criteria for lawful contract termination. He added, from the injunction materials, it seems there was fierce conflict between MINHEEJIN and HYBE, but the court concluded that HYBE still has the ability to provide a capable producer. Since we have more time in this main trial, there should be proposals or compensatory discussions. So at this point, let's summarize what the judge said. First of all, the NewJeans side demanded that ADOR fix 8 issues and warned they would terminate the contract if the issues weren't resolved by November 28th, right? NewJeans gave ADOR a list of problems they wanted fixed and set a deadline saying they would terminate the contract if the issues weren't addressed by then. And one of them was the issue with dolphiners, which I made a video about yesterday, I think. And ADOR responded to the demands on November 28th, just one day before the deadline. But NewJeans held a press conference and announced contract termination before even reviewing that response. So this means that ADOR did respond, right? 26 pages long. Where'd it go? Yep. But NewJeans went ahead and declared the contract terminated without even checking ADOR's reply. And 3, if you want to terminate a contract, the judge basically said, you have to prove the reasons for doing so. But instead of providing proof, NewJeans simply announced the termination unilaterally. So, yes, the burden of proof legally lies with NewJeans. They must show that ADOR seriously breached its obligations. And the judge is pointing out that they haven't done that sufficiently enough. And when asked whether a settlement was possible, ADOR said they were open to it. And this has been their stance ever since the beginning. They're asking NewJeans to come back to ADOR. We have everything prepared for you, even a large-scale fan meeting, an album, and even a world tour. But NewJeans' legal representative replied, the members are not in a state of mind to even consider that at this point. So according to the article, they said 현재로서는 ATP at this point. We'll have to see what they mean by that. But at this point, at least, the members are not in a state of mind to even consider that. All right, so, and then each side started to make their own arguments. Starting with ADOR. ADOR's legal team argued, according to case law, the burden of proving valid grounds for termination lies with the defendants. Their claims were delayed and only partially submitted. If more is presented, we will make a rebuttal point by point. As for producing, the defendants insist they can't continue without MINHEEJIN. While she undoubtedly contributed, claiming that NewJeans is impossible without her is illogical. And as a HYBE label, ADOR has industry-leading resources. The defendants prepared and completed their Hong, and check this out, this was a killer. The defendants, meaning NewJeans, prepared and completed their Hong Kong performance independently, which contradicts their claim that only MINHEEJIN can make their work possible. When asked by the judge if Min was involved in the Hong Kong performance. ADOR responded, to our knowledge, she was not. So let's break that down. So ADOR's main arguments were as follows. The burden of proof is on NewJeans to justify why they're terminating the contract. But NewJeans raised their claims late and submitted only partial evidence. Thus, ADOR argues that the grounds NewJeans has presented are insufficient. If NewJeans submits more claims, ADOR is prepared to counter them in court. Now, NewJeans claim that NewJeans can't exist without MINHEEJIN doesn't hold water, which is the exact question that I presented to the so-called bunnies last year. Why do you think that NewJeans is nothing without MINHEEJIN? Right? While they acknowledge that MINHEEJIN contributed to some extent, ADOR said, HYBE is a top company in the industry and is fully capable of providing alternative support. And it turns out, according to the injunction case court hearing last time, Bang Sik himself contacted the former VP of ADOR even before this whole thing broke out, that he's very willing to connect NewJeans with top-tier global producers out there, right? So they got the resources. What do you mean they cannot find alternatives after MINHEEJIN? And now, NewJeans independently prepared for and successfully performed at the Hong Kong concert without MINHEEJIN. So, the claim that nothing is possible without MINHEEJIN contradicts their own actions. The judge even asked, did the Hong Kong show really happen without MINHEEJIN? And ADOR confirmed, yes. And yes, indeed. And here are the professional-looking videos. Interestingly, uploaded by the Team Bunnies. I'm not sure if this is the Team Bunnies, at least that's what it says on their description. They added a link to the Team Bunnies X account. But yeah, now, the reason why this was a very interesting argument is because NewJeans' Hong Kong performance created a no-win situation for them. If they perform without MINHEEJIN, it undermines their argument that they can't function without her. But if they did get her help, that opens the door to accusations of tampering and unauthorized collaboration. So people are mockingly dubbing this as a trap, a very clever trap set by Kim and-jung, the top legal, the law firm in Korea. They're doomed. They're damned if they do, damned if they don't. So ADOR really played the perfect trap card, people said. So that was what ADOR said. What about NewJeans' side? What kinds of fantastic evidence do they have this time? Well, let's check it out. NewJeans' legal team, Sejong law firm, Shin and Kim, stated, while MINHEEJIN played a vital role, the issue isn't just her absence, but the lack of any communication or alternative plan from ADOR. They had 6 to 7 months after the conflict began and still didn't propose any workable solution. That's part of our argument. They emphasized the lack of alternative planning and communication, not just Min's absence, is what we see as central. We'll submit the rest in writing. The team also stated, even if each individual reason isn't enough to justify contract termination, when taken together, they clearly show a complete breakdown of trust. The current ADOR, with an entirely new leadership team, is effectively a different company from the one the members signed with. This isn't just about MINHEEJIN. The ADOR that exists now, after her removal, is not the same entity. Forcing the members to stay with this new ADOR isn't justice. Okay, so let's break that down. So they essentially said, MINHEEJIN wasn't just a producer, she had deep meaning and influence for the members. And ADOR had 6 to 7 months before her removal to come up with an alternative, but did nothing. This shows that ADOR had no real intention of supporting NewJeans. The problem isn't just that MINHEEJIN left, it's that she was removed unilaterally without any alternative plan or communication. It's not about whether NewJeans can work without Min Hee-jin. It's about the lack of fairness and communication in how things were handled. And the breakdown of trust isn't due to a single event, but the accumulation of many. And they said this, maybe each issue alone wouldn't justify termination, but together they have destroyed our trust. They argued that after new leadership took over and Min Hee-jin left, ADOR may legally be the same company, but in reality, it's a different organization. Now, when it comes to that last point, people are like joking. Like, what do you mean by that? Do you mean that all of a sudden the president of Korea changes? That means that we have a new nation? Or like, let's talk about Apple, for example. So Steve Jobs, after Steve Jobs, Tim Cook began to lead the company. Doesn't mean that we all of a sudden have a different company, new company. What do you mean by that? So that's what people are pointing out. And when it comes to the second to the last point, maybe each issue alone wouldn't justify termination, but together they destroy our trust. So this gallery, online community gallery called Five Fingers, this is a space for those former bunnies, those who used to be fans of NewJeans but left the fandom entirely, gather together and diss Min Hee-jin and even the five members. Jokingly said, the summary of today's court, and then they just copy and pasted what I just read. The argument made by NewJeans, and say that, okay, so you mean that 11 BSs, when they're combined, all of a sudden have capabilities as evidence, like evidence, power as evidence. And they're comparing that to like robots, 변신 robot. So that was kind of funny. Now, also, this. NewJeans claims that ADOR failed to provide an alternative during the 6 to 7 months before Min Hee-jin left, right? But if ADOR had prepared an alternative, people believe that NewJeans would have said, anyway, they were sidelining Min Hee-jin. That proves the trust is broken. So it leads to the perception that no matter what ADOR did, NewJeans and their supporters were going to frame it as betrayal, like a self-serving, lose-lose narrative critics liken to emotional blackmail, right? And someone summed it up. This issue isn't even Min Hee-jin herself. It's that whenever things don't go their way, they cry loss of trust. Now, to that, ADOR responded. Min Hee-jin wasn't ousted. She left of her own accord. And that is very true, right? That is very true. She even shared this photo saying, I quit. This photo of a rabbit or a bunny on her Instagram account saying, I quit. And remember, ADOR asked her to serve as an internal director, not as CEO. That's a no-no. But they basically said that, okay, I mean, you can serve as an internal director and you can even serve as a producer. Please continue to serve as NewJeans' producer. But then she quitted and left the company. And that's what ADOR is pointing out. She wasn't ousted. She left on her own. Even after the court approved a leadership change, we offered her a board seat and producer role. She refused unless she was reinstated as CEO, delayed with excuses, and then left. The members then abruptly declared contract termination. ADOR didn't even have time to develop alternatives or properly communicate with the members. We had no options left. It's not fair to claim that we simply cut off producing support. And it doesn't say whether NewJeans' side was able to refute that argument just made by ADOR. Now, what do you have now? Okay, and then the judge remarked, a breakdown of trust is a vague concept, and I don't know how each person interprets it. I have handled cases where artists never received any payments or exposure and asked to end their contracts. That's typical. So he is experienced with this kind of case. it says. This case is very unusual, he said. Exact wording is... Okay, yeah. This case is very unusual. Are we saying that NewJeans wouldn't have signed with ADOR in the first place if MINHEEJIN wasn't there? Is that what this boils down to? I'll think more deeply about what constitutes trust in a management contract and whether it extends to things like producing. This is certainly not a common scenario. Now, if you read this in Korean, and there's a reason why I decided to read this article instead of the one more clearly summarized, because I think this journalist wrote like word for word their remarks word for word, and it kind of sounds like the judge believes that what NewJeans side saying is kind of ridiculous, but he's doing his best to sound very objective, right? Which is why he said this is certainly not a common scenario, instead of saying that, okay, this simply doesn't make sense, right? And Korean people have noticed this difference. All right, and then it says the next court date is set for June 5th. So let's break down what the judge just said. Key takeaway: the concept of a breakdown in trust is highly subjective. What feels like broken trust to one person may not feel that way to another. The judge compared this case to previous management contract disputes that he himself has handled, where the ADOR members had never debuted, never received any earnings, and were seeking to terminate contracts under much more clear-cut hardships. And in those cases, claiming a loss of trust made more legal sense. But in NewJeans' case, they successfully debuted, received full payments, made like 5.2 billion Korean won in their first year, according to articles, and achieved significant success with ADOR. And now they're claiming that trust is broken because MINHEEJIN is gone, which the judge sees as very different from the typical precedents. The judge gave an example. If trust were truly broken, wouldn't they have avoided joining the company in the first place? Wouldn't they have refused to train there at all? So essentially, the judge is saying, I'm not sure if this really qualifies as a legal breakdown of trust. I need to think more carefully about that. So in simpler terms, other idols try to get out of contracts without ever making money or debuting. But NewJeans debuted and got paid. So now saying we can't continue without MINHEEJIN, is that really a breakdown in trust? I'm not convinced just yet. And it sounds like that's exactly what the judge is trying to say. So let's recap. First, loss of trust isn't enough to end the contract, right? NewJeans argued, and they've been arguing, that they could no longer trust ADOR without MINHEEJIN, citing a breakdown in trust as a reason for terminating their contract. But the court doesn't make rulings based on emotions. It rules based on law and evidence. The judge made it clear. Breakdown of trust is a vague, abstract concept, and I think some of my subscribers have pointed out that maybe in the future that term should be removed from the contract entirely, because it's such a vague and abstract concept. And without a proof of a contractual breach, it's not a legal reason to terminate. Simply announcing that trust is broken doesn't meet the threshold. And the judge is already skeptical, it sounds like. The judge questioned whether NewJeans followed the correct procedure in ending the contract. He pointed out that ADOR sent a reply to the group's complaints before their press conference, and that NewJeans didn't honor the required 14-day grace period. And the procedural misstep could render their termination legally invalid, even if the members felt distressed. Failing to follow the contract terms significantly weakens their case. And because the judge sounds already skeptical, some articles have made the title like this. NewJeans said, we cannot do anything without MINHEEJIN. ADOR said, oh, you actually can. And then the judge said, this is, unique or this is weird. Yeah. All right. Next. On the other hand, compared to NewJeans or the Sejong law firm, ADOR side and Kim In-jang legal position is pretty solid. They have approached the case strategically and by the book. NewJeans' claim that there's no NewJeans without MINHEEJIN is contradicted by the fact that they were able to prepare and perform at Complex Con in Hong Kong as NJZ without MINHEEJIN. And ADOR also pointed out that as HYBE's top affiliate, they're more than capable of providing alternative producers. And saying they just can't is not unrealistic, but also legally unconvincing. And NewJeans' argument, just like they have been doing so, is emotionally driven. They claim that ADOR is no longer the company we signed with because of MINHEEJIN's removal. But the judge pushed back, right? Leadership changes are common in K-pop, and artists can't use that as grounds to void a contract. And yeah, the judge described this case as highly unusual, 특이하다, and questioned whether the absence of a specific producer alone is enough to say trust has been broken. And ADOR is still open to settlements, and NewJeans is not, right? In the very beginning, the judge asked whether reconciliation was possible. ADOR expressed interest, but NewJeans' side firmly said now is not the time, citing the members' emotional state. Now, I noted that their wording was 지금으로서는 or 현재로서는 at this point. So we'll have to see if they're gonna change their stance. But if they're going to be hold their stance as firm as this, that could be a costly mistake, right? Because if they lose the main case, NewJeans may face huge penalties for breach of contract and reputational damage. That has been already done, I think, especially after their interview with the Times Magazine, and financial liability for lost profits and brand value. And summary, it turns out that NewJeans' legal argument is emotionally charged, abstract, and weak in terms of legal grounding. And this is kind of disappointing given what the NJZ PR account the parents have said a few weeks ago, right? What did they say? The main lawsuit allows us to freely utilize civil procedure tools to collect necessary evidence. We anticipate this will greatly reinforce our claims. But we'll see. Maybe they have some secret weapons, secret evidence they had in store and will submit to court in writing, and maybe that will change the game. We'll have to see. But so far, it seems like they have yet to present clear evidence of a contractual breach. And that's not surprising because we all know that they don't really have the evidence. Meanwhile, ADOR is backing his case with procedure, documentation, and a realistic understanding of the industry. And yes, the next hearing will be happening on June 5th. And unless NewJeans comes forward with concrete legal violations, they risk, losing in court, but also in the court of public opinion. But I think they have already lost in that realm, in the court of public opinion. All right, now let's see what bunnies are thinking about this case. The bunnies, the fans who used to be bunnies, now left the fandom, pointed out the nuance in what the judge said, right? Because the judge is trying really hard to be careful about his wording. Try not to hurt their feelings, like NewJeans' feelings. And he added words like, I'm not sure if I'm right, or maybe I'm wrong, something like that, 내가 잘못 생각할 수도 있습니다. Maybe my thinking is wrong, something like that. But it's clear that he's not really following the NewJeans side's logic. And this comment, this is hilarious. I bet the judge thinks that this is so BS and he wanted to say what's on his mind, but as judge, he must stay neutral. And then, yeah, this person also within the same gallery is highly criticizing the Sejong law firm. Like, what are their lawyers doing? They're repeating what they have been saying all along. And you know what? I'm gonna talk about that later at the end. So I already covered this. Now, what are the current bunnies saying? This is kind of okay. I wish, it says. I think this is from X, also shared by the former bunnies. The title of this post, sharing this X post, is that the fact that they're wishing that the judge is shy bunnies is very weird. So the post says, I wish the judge was a shy bunnies, someone who is bunnies but hiding that fact. But that's just wishful thinking. It's clear that the judge is overseeing this K-pop case and don't really understand what's going on. Even the finances and settlements, those only happen because Min Hee-jin was in charge. 대표님, the CEO. So why can't you tell the difference now that the emojis for pigs are the ones, I think they're referring to Kim Joo-young, the one leading ADOR, different CEO, and the one employed by HYBE. Are you seriously confusing this fake ADOR? They said. And Sejong, you need to clarify this. But the writer of this post, sharing this post, said that, the fact that they're trying to gaslight even the judge is super weird. But they didn't know that, it said. And yeah, it's kind of weird that they photoshopped the faces of HYBE executives onto North Korean soldiers. And yeah, the writer of this post is making fun of this Twitter or X account user, saying that their mindset is more like North Korean. All right, what about this? Also from X, conversation among the current bunnies. Now that I think about it, maybe the judge doesn't even know the entertainment industry well. They might be more clueless than the general public. Sigh, you. We should go by the law. Why do I get the feeling this judge is trying to insert personal feelings into the ruling? The judge's stance feels way too similar to the one before. Makes me nervous. And then on the top we see, hey, dear judge, do your job. 잘하자. I think they're kind of threatening the judge. Yeah, there we go. That's what I just read. All right, meanwhile, Team Bunnies has made this post. Sending letters of support to members. Please send letters of support to the members. The letters will be reviewed and delivered to the members. Now, so they have created this link. You have to insert your email address and your name. And then if you click next, you get to write your message and submit. But they added, if you continuously send incorrect information or send malicious messages, your access to the website may be blocked. Please enter your email and name information accurately so that we can notify you of the delivery status of your letter. And people are criticizing that, okay, now they're doing this so that the members who are stressed or maybe thinking about joining ADOR, they can prevent them from leaving, by showing these letters of support. And they will obviously censor whatever messages that are against them, because they have previously declared those who don't agree with the members are not bunnies. We're not going to consider them as bunnies, said Team Bunnies, right? So, yeah, whatever messages of criticism will not get through. And they're saying, oh, wow, this is ridiculous or something. Oh, and the title of this post, sharing the Team Bunny's post, says that, okay, is there a higher chance of winning the main lawsuit if you receive support messages? And yeah. Now, what about this? This is... So, I'm not sure if this is real or not because I have not seen this in person. But I guess there's a Kakao Talk conversation message room existing filled with bunnies sharing and collecting HYBE's controversies or controversial evidence or controversial behaviors by HYBE. And then they're saying things like, okay, I think right now is not the period for evidence submission, but we don't really have any evidence. And they said that, okay, with evidence, such claims could hold strength, but we don't know whether such evidence exists at all. So this is really concerning. And at the very bottom, someone says, it would be great if ILIT members could testify, but I think that's impossible. And as soon as I read that, I was like, are they seriously hoping that ILIT members will testify on behalf of NewJeans? The same ILIT members that have been witch hunted by the bunnies and even targeted by NewJeans members themselves during the previous court hearing. They specifically mentioned ILIT and LE SSERAFIM. So that was kind of ridiculous. All right. What shall we end? Yeah, I think. Oh, yeah, I got it right here. High controversy info sharing room. Pin message. Hello, this is the info sharing room for the high controversy. I don't think it's the period for submitting evidence yet. There just doesn't seem to be any evidence at all. Claims like that would only hold weight if there's evidence, but we don't even know if any exists. So it's a really frustrating situation. It would be great if Ali could testify, but that seems impossible for now. Wow. That's all I'm gonna say. All right, did I cover everything? Oh, did I read this for you? Yeah, maybe I should end with this. So, the judge said that it looks like ADOR does have capabilities to provide alternatives for MINHEEJIN. And that's directly from the decision made by the judge in the previous injunction case, right? Grounds for termination listed in the notice of rectification. It appears that MINHEEJIN, who was formerly the CEO of the creditor, ADOR, was deeply involved in the musical activities of the debtors, NewJeans, as their producer. However, the dismissal of NewJeans as CEO, the dismissal of MINHEEJIN as CEO and the appointment of a new CEO fall under the creditors' management decisions and are not directly related to the production work for the debtors. Even after being dismissed as CEO, MINHEEJIN could still have participated in production activities for the debtors in her capacity as an internal director. And in fact, the creditor ADOR offered MINHEEJIN to remain as an internal director and to continue overseeing NewJeans' production work through a service contract until the end of their exclusive contract period. Nevertheless, MINHEEJIN declined this offer around November 20, 2024, and voluntarily resigned from her position as internal director. Yes. While it is true that ADOR did not secure a replacement producer for several months after dismissing MINHEEJIN, this appears to be because ADOR was awaiting a response from MINHEEJIN regarding the production offer. The exclusive contract in this case does not contain any clause requiring that only MINHEEJIN be in charge of production for the debtors, for NewJeans, nor does it appear that such a condition was the motive or purpose behind entering into the contract. There is no provision in the contract allowing NewJeans to terminate it simply because Min Hee-jin is no longer CEO or does not carry out production duties for them. The creditor appears fully capable of securing a producer to replace Min Hee-jin, meaning ADOR, appears fully capable of securing a producer to replace Min Hee-jin. Taken together, these points suggest that the dismissal of Min Hee-jin as CEO does not, in itself, mean there was a disruption in production work for NewJeans, nor does it justify the conclusion that the creditor lacks the intent or ability to continue fulfilling that role. So that was a part of the decision that the judge made for the previous injunction case. And chances are, according to a lot of experts, legal experts, there's a super slim chance that NewJeans could turn this case around. But we'll see. Like I said, maybe they have some fantastic secret evidence that no one knows about. And as long as it's not fabricated, just like the ignore her remark that was originally coined by Min Hee-jin herself, that she gaslighted into Honey's brain. We'll see if they're gonna submit any useful evidence. All right. One last thing about Sejong Law Firm. So a lot of Korean people are saying that this whole thing, like being serving NewJeans and Min Hee-jin as their lawyers, has really damaged Sejong's reputation and public image. And I kind of agree with that because they're basically repeating what they have been saying all along. And in fact, they kind of embarrassed themselves previously. There's an article from January 20th, how like when they were serving Min Hee-jin, their legal team made a critical error in court by falsely claiming that Eyelid debuted 8 months after NewJeans, and using this timeline to support allegations of plagiarism. But the fact is, Eyelid debuted 19 months after NewJeans, not 8. And why did they make this mistake? Probably because they're repeating exactly what Min Hee-jin told them to say, or use the evidence that Min Hee-jin herself gave them without fact-checking. So that's kind of embarrassing. And I don't know, reading about their arguments simply from articles makes me kind of concerned. Like, the Sejong Law Firm is one of the most well-known and powerful law firms in Korea. And the chances are, of course, many people will forget about this whole thing in a few years. But those who do, like me, when they hear about Sejong from now on, they're going to have this image. Oh, the law firm who represented NewJeans and Min Hee-jin and who sounded ridiculous in court. The law firm who Min Hee-jin dearly loved by giving a shout out, Sejongdae, during her conversation with her fans last year in May. And the law firm whose lawyer, after winning the first injunction case with Min Hee-jin, said that the reason why I was smiling is because I knew we would win. And that, I don't think, is a good PR for them, this whole case that has been going on for months. But like I said, many people will forget about this. But I think I'm going to remember them for a long time. All right, with that, I'm going to wrap it up. Let me know what you guys think about this case. Will NewJeans submit any real and useful evidence and turn this thing around? And what will happen in the end? And what kinds of decision will this judge make? We'll see, and I will update as new information arises. All right, see you guys later. Feel free to leave comments But let's stay positive, respectful, and classy as always. Thank you guys. Peace and love. Bye-bye.